Welcome to today's audio explainer series, Legal Matters, Stories of Law and Justice, where we unravel the intricate legal narratives that have the power to shape and transform lives. In each episode, we bring you a story that unfolds in a courtroom or a law chamber and offer you a ringside view into the heart of the legal process. Today, we take a deep dive into a recent case from India that exposes the challenges within India's juvenile justice system. I'm Yamuna Rizvi, I Pro Bono Program Officer, and I'll walk you through this story. Reformation, rehabilitation, reintegration. These values are at the core of India's Juvenile Justice Act 2015. In fact, one of the ideas behind the provisions of the Act is to avoid institutionalization of children accused of a crime. But unfortunately, things often don't work that way in practice. For a number of reasons, young detainees often find themselves caught up in a web of legal complexities. Some of them end up spending their formative years in a place of safety, also called Bacha Jail. Under the Juvenile Justice Act 2015, a place of safety is an institutional mechanism that provides a safe place of stay for children in conflict with the law. This is what happened in a case of a 17-year-old boy whose case I Pro Bono encountered recently. To protect his identity, let's call him Rahul. Even though Rahul wasn't convicted, 5 precious years of his life were lost because of delays in securing a bail order. Let's go in detail about his case and understand where the lapses happened. In 2018, Rahul was accused of trespassing and causing the death of a security guard. While there was little proof connecting him to the crime, he was apprehended and placed in a place of safety. Since the charges pressed against him were heinous, he had to undergo a preliminary assessment. This procedure was put in place by the new Juvenile Justice Act of 2015. Under this provision, if a child in the age group of 16 to 18 years commits a heinous offense, the Juvenile Justice Board will conduct a preliminary assessment to find if he or she is fit to be tried as an adult. The JJB's task is to evaluate whether the child has the mental and physical capacity to understand the consequences of the alleged crime. The PA process is currently under challenge on the ground that it fails to take into account the circumstances the child comes from, his or her capacity to understand the consequences of the act. In Rahul's case, the JJB made conclusions based on his involuntary confession and physical and mental capacity in general. The JJB also failed to take into account the fact that his father's demise when he was very young left his mother struggling to provide for him and his siblings on the meager salary she earned as a manual laborer. Rahul never had access to schooling. He was living on the street, became a drug user, and fell in bad company. Despite these circumstances, the JJB transferred Rahul's case to the adult justice system in 2018. In such cases, although the child is still entitled to bail, the courts are often reluctant to grant it. For the next 5 years, Rahul remained in the place of safety, what children in the system often refer to as Bacha Jail. His case barely progressed and he received no support from legal systems that are meant to protect children. For instance, because he had lost contact with his family after his detention, they could not ensure that he was properly represented. The legal aid lawyer provided to him by the government failed to file a single bail application and did not appeal against the questionable preliminary assessment. Rahul was not even informed about his right to appeal against an unfavorable order. This is a stark indication of the kind of pro bono representation that vulnerable children like Rahul have access to. In June 2023, I Pro Bono received Rahul's case and we promptly initiated legal representation by filing a bail application on his behalf. After lengthy arguments, an order granting bail was passed on 19 September 2023. However, Rahul's journey was still not over. A requirement for an under trial, and in this case a child in conflict with law, to be released on bail is someone to stand surety. This means they take responsibility for the person who is released on bail. In the absence of family support, there was no one to stand surety for Rahul. Now, the Juvenile Justice Act 2015 does allow for bail without surety under the supervision of a probation officer, but the court was unwilling to agree to this in Rahul's case. Eventually, Punita Roy, the managing trustee of Yuva Ekta Foundation, who had interacted with Rahul during the course of her work at Place of Safety, volunteered to stand surety for him. I Pro Bono's panel lawyer took the next step of filing the bail bond on 21st September 2023, and Punita personally appeared in the court. She was told that a police verification would be conducted and then she would be called again. The police verification report took 2 days, and once again the matter was listed in court. Punita appeared again, hoping that this would be her last visit and Rahul would be released. This time the court had another doubt. Where would Rahul stay after his release? The court refused to allow the release papers to be signed unless there was clarity on this matter. According to the law, in such circumstances, it is the responsibility of the probation officer to care for the child upon their release. But in this case, Rahul was asked to find a place to live. He has been isolated from the outside world for 5 years. How would he manage to find a place before his release? Once again, someone stepped up to take the responsibility. Rahul's friend, whom he met in the Place of Safety, agreed to help him and convinced his father to let Rahul stay with his family. The court was informed of this on the next date, at which point yet another condition was laid down, that the person in whose house Rahul would live should appear before the court and submit an affidavit. Since the man in question was travelling, there was a further delay. Finally, after these additional 21 days of delays, on 11 October 2023, the necessary documents were signed and Rahul was released on bail. To sum it up, it took 2 NGOs, a pro bono lawyer, a friend's father, more than 5 years of waiting before Rahul could leave the childcare institution where he was held. A lot of time and resources were required to secure his bail under the Juvenile Justice Act, which in theory is designed to make access to justice for minors easy. The real tragedy is that Rahul's case is not unique. He is merely one of many children in conflict with the law who are languishing in detention for years awaiting trial. His case shows the lapses in the system and also explains the urgent need for reform within the juvenile justice system. The principles of institutionalization as a last resort and the presumption of innocence are being compromised. These are not just legal principles, they represent basic human rights. Thanks for listening to our explainer on this story and why each of these stories matters in the fight to protect the rights of the children. Stay tuned to our audio series Legal Matters, Stories of Law and Justice, as we bring you more such stories from the legal world that make a difference in people's lives.